Rozier Jr. are presiding. Good morning to everyone. We are here for trial in Wake County file number 18 CDS 15292. This is the matter of Jabari Holmes, Fred Culp, Daniel E. Smith, Brendan Jaden Pay, Chakoya Kerry Brown, and Paul Kearney Sr. plaintiffs versus Timothy K. Moore in his official capacity as Speaker of the North Carolina House of Representatives, Philip E. Berger in his official capacity as President Pro Tem of the North Carolina Senate, David R. Lewis in his official capacity as Chairman of the House Select Committee on Elections for the 2018 third extra session, Ralph E. Heiss in his official capacity as Chairman of the Senate Select Committee on Elections for the 2018 third extra session, the state of North Carolina, and the North Carolina State Board of Elections. In accordance with the emergency directives of the orders of the Chief Justice of the Supreme Court of North Carolina, this proceeding is being conducted remotely through video teleconferencing. That also with the consent and request of all parties involved in this case. In accordance with Section 18 of Article 1 of the Constitution of North Carolina, these proceedings are open to the public via a video link to the proceedings through the Wake County Superior Court's YouTube live webpage. All microphones shall remain muted unless you are addressing the court. Please identify yourself each time you speak so that the court record is accurate. Court personnel present in this trial are the presiding judges, the courtroom clerk, and the court reporter. These proceedings are being recorded by the court reporter, and no other recordings are authorized, including video recording, still photography, and screenshots. Again, these proceedings are being live streamed, I believe, through the Wake County Superior Court's YouTube live webpage. And it's my understanding that this morning there has been a request from the press to broadcast these proceedings, and that permission has been granted. I would be glad, I know that we've entered a pretrial order in this case, but I would be glad to allow the plaintiffs to begin with their opening statements at this time. Are there any questions before we do that? Are there any questions by anyone before we go any further?
Yes, Your Honor. Allison Riggs on behalf of plaintiffs. If I could seek the court's indulgence for just a couple of housekeeping matters. First, our first witness testifying today is Elizabeth Holmes, the mother of our lead plaintiff, Jabari Holmes. She's testifying from a hotel conference room near her house because we were worried about the internet connectivity at their house. She cares for her profoundly disabled son and her ill husband, and we want to make sure she's away from them as little as possible. I was wondering if it might be possible, in light of our later start this morning and openings and other housekeeping, if we could take a slightly earlier lunch break so that Mrs. Holmes could testify right after lunch and not have her testimony interrupted by the lunch break, just to get her home quicker. I've consulted with legislative defendants and the defendants, and they have no objections.
I certainly understand that and believe that that will be more than fine. Thank you very much.
Thank you, Your Honor. And then plaintiffs have spoken with legislative defendants, and we would like to invoke the rule on witness sequestration. So we have informed all of our lay witnesses, non-party, non-expert lay witnesses, to not watch the live stream, and just wanted to confirm that for the court.
All right, now have the legislative defendants, Mr. Thompson, Mr. Cox, do you wish to be heard about that?
Your Honor, we are fine with that. We have no objection.
All right.
We also have no objection, Your Honor.
All right, then the court will enter an order requiring all witnesses to remain outside of the courtroom. and not watch these proceedings until such time as they testify. Now, after they testify, generally, I allow witnesses to remain in the courtroom. And so unless I hear otherwise, that would be the rule today, or throughout this trial, is once a witness testifies, the sequestration order is no longer in effect as to that witness.
Thank you, Your Honor. This is Allison Riggs. And to be clear, we seek to invoke the rule as it normally is applied, meaning it doesn't apply to expert witnesses.
Mr. Cox, Mr. Thompson, do you agree with that?
Yes, Your Honor, that's fine.
Yes, Your Honor.
All right, then the order would not be in effect as to any and all expert witnesses testifying in the case.
Thank you, Your Honor. One last issue before we move into openings. An issue has arisen over this weekend relating to one of the witnesses that plaintiffs would like to call in their case in chief, and I'd like to hand over to my colleague, Mr. Brockman, to address that issue and see if the court would like to deal with it today.
Good morning, Your Honors. Can you hear me clearly?
Yes, sir.
Oh, thank you. So the plaintiffs would like to call in their case in chief former Senator Joel Ford. We've advised the defendants of that, and we have served former Senator Ford with a subpoena for his trial testimony. Our understanding is that the legislative defendants object to plaintiffs calling Senator Ford in plaintiff's case in chief. We have prepared a motion seeking an order directing Senator Ford to comply with the trial subpoena, which we can hand up virtually if it would please the court, or if there's a more convenient time for argument on the issue. My colleague Amitav Chakraborty in New York is prepared to provide some brief argument to the court.
Mr. Thompson, Mr. Cox, do you wish to be heard about that?
Yes, Your Honor, we would like to be heard just for a brief moment, and my colleague, Ms. Moss, will articulate our views on this topic. Thank you, Your Honor.
Good morning, Your Honor. This is Nicole Moss. Can you hear me okay?
Yes.
Okay, great. Thank you. Yes, just very briefly, what we have made clear to the plaintiff's counsel is that we don't object to Mr. Ford testifying. Indeed, we have identified him as a witness that we intend to call. He's been identified as our witness since 2019. Plaintiffs, throughout discovery in this case and throughout the agreed exchange of witnesses that they would be intending to call, did not identify Mr. Ford until the day before the final order of witnesses was due, in which they, for the very first time, identified him. And we explained that as a non-party, third-party witness to this matter, that we believe under Rule 45's requirement that they minimize the burden on subpoena recipients, that they should reserve their questioning until cross-examination after we call Mr. Ford, so that he does not have to both worry about complying with the subpoena that they've issued and then perhaps have to come back in our case. They would have complete ability to ask him whatever questions that they wish at that time. And we even made clear that we would be willing to accept that subpoena if they had some concern that despite our repeatedly, again, since, really very shortly after this lawsuit was filed, identifying him as somebody that we want the court to hear from. If we at the 11th hour decided not to call him, we made clear that, we would accept a subpoena that they could have him come and testify. So this is really just about, whether it's appropriate to burden this third party with perhaps having to hold himself open to appear on the 15th, which is the day the subpoena that they issued specifies, on the 16th, which is the day I believe they've actually indicated that they're likely to get to him, and then have to come back again the next week for legislative defendant's case. The court is going to hear from him, but we simply ask that the court minimize the burden on this non-party witness.
All right, thank you very much. I'll tell you what I'm going to do is take the matter under advisement. I'll have a chance during a break or perhaps over lunch to speak with the other judges about the issue. If we need to hear further from anyone about that issue, we will let you know. Otherwise, we'll probably give you a ruling about that maybe after the lunch break today, or if not, then probably first thing tomorrow morning, okay?
Your Honor, would you like this is Allison Riggs. Would you like us to email submit our motion or otherwise explain our position on what we're seeking to do?
You may, yes, if you'd like, but you know, I think I've heard from you just now, and think I understand the positions. But to the extent we don't, you certainly are welcome to submit anything that you'd like.
Thank you. We will submit a written motion, but just if you'll bear with us, I think we may have just lost Amitav. Your Honor, we believe that, oh, there's Amitav. If we could beg your indulgence for just 2 minutes so my colleague Amitav could highlight a couple of the reasons why we think this is so important and
Oh, sure,
not
that's
hurt
fine.
them.
That's fine. I see him speaking, but I cannot hear him.
Apologies. How about now?
I do hear you now. Yes, sir.
Good morning, Your Honors. Amitav Chakraborty, appearing on behalf of the plaintiffs. Thanks again for allowing us to be heard briefly on this issue. Your Honors, as plaintiff, we bear the burden of proof in the case, and our position is that we're entitled to put on our case in a manner to best meet that burden and call our witnesses, including any hostile witnesses, such as Mr. Ford, in the order that we see fit. To the point about when Mr. Ford will be called and, you know, when we decided to put forth his name on our witness list, legislative defendants have had ample notice about the fact that we may call not only Senator Ford, but any other witnesses appearing on their trial witness list. We let them know 5 months ago in our interrogatory responses, and we reserved that right in our initial witness list about 2 months ago. As legislative defendants noted, nearly 2 weeks ago now, we decided and we told them that we would like Senator Ford to appear as part of our case in chief. We did that in accordance with our joint pretrial order, and we exchanged that with legislative defendants on April 2nd. As Ms. Moss noted, Senator Ford will appear in this case either way. So it's a question of whether he will appear a few days earlier or a few days later. Because we believe that we should have the right, as all plaintiffs do, to put on our case in chief in the best way to make our case and meet our burden, we think he should testify earlier. Thank you.
All right, thank you all very much. Again, I think that we'll talk about that among the judges, and then we'll get back to you with a ruling about that just after lunch. I hope that that's soon enough. But thank you for your arguments. And if there's anything else that you all would like to submit, you probably need to submit that before lunch. All right, Ms. Riggs, are you ready for the plaintiff's opening at this point?
Yes, Your Honor. Thank you so much.
I
May it
believe
please.
I believe the pretrial order, it may have mentioned 45 minutes. Is that accurate?
That is most certainly what I'm shooting for, Your Honor.
Okay, great. Thank you.
May it please the court. My name is Allison Riggs with the Southern Coalition for Social Justice, and with my colleagues at SCSJ and the law firm Paul Weiss, it's our great honor to represent plaintiffs in this matter. On behalf of both my clients and co-counsel, we'd like to thank the court and its staff for its time, assistance, and consideration in this important matter, and for agreeing to hold a trial in a manner that allows us to keep everyone as safe as possible. This case is, of course, about intentional racial discrimination. During trial, we will prove that North Carolina passed a law to keep Black voters from voting. The United States Supreme Court has established a roadmap for proving intentional discrimination cases through circumstantial evidence, but in short, no damning statements from legislators are necessary for plaintiffs to prevail. Here's the overview of how I plan to spend my time in opening with you. I'll go over the applicable legal standard, the Arlington Heights standard, particularly as it should be applied under the state equal protection guarantee in Article 1, Section 19. I'll also, within that framework, then briefly forecast for you the evidence that we will present. After talking about what the law is and where the evidence properly plugs into that law, I do want to spend a bit of time telling you what the law is not in this case. This court has certainly been inundated with briefing in the last 2.5 years. And having read all of it, I think it would be easy to have some misconceptions about the legal claims at issue. I want to confront those head on before you listen to the evidence. As the North Carolina Court of Appeals noted in its binding decision on the law of this case, parties are in general agreement that the analysis in Arlington Heights governs here, but there are a couple of caveats. The parties do dispute the proper application of the Arlington Heights standard. Plaintiffs think that the significantly more protective qualities of our equal protection guarantee in Article 1, Section 19 means that the standard should be applied with even more vigor than it is under the 14th Amendment cases. And we will certainly have more evidence than even what was before this court and the Court of Appeals at the preliminary injunction stage. So what does Arlington Heights say, and how is it properly applied? The Supreme Court in Arlington Heights said that plaintiffs bringing an intentional discrimination case and the court reviewing those claims must perform an, and I quote, sensitive inquiry into such circumstantial and direct evidence of intent as may be available. Obviously, this court is familiar with the distinctions between circumstantial and direct evidence, but courts for the last 20 to 30 years have been clear that in these kinds of cases, there are no more smoking gun pieces of evidence. Motives are hidden, and we just don't have that kind of evidence anymore. And most importantly, plaintiffs are not required to come up with that kind of evidence in order to prevail. What does a sensitive inquiry mean? Sensitive means looking at the evidence in the broader context. It is wrong to take each piece of evidence and assess it in a silo without placing it into the larger context. The federal guidance on the interpretation of Arlington Heights is also clear that improper intent does not need to be the sole or primary motive behind the legislation. In fact, the Supreme Court has said it just needs to be a motivating factor. So what does that mean in practice? A motivating factor means that the improper motive is at least in part the reason and the reason for the legislation. So in part, the legislation was passed because of, not in spite of, the improper motive. The United States Supreme Court has emphasized that latter part, that because of, not in spite of, but it has also emphasized the a motivating factor. So to the extent there's any tension between Arlington Heights and that later cases on that, and I don't think there is, our more protective equal protection guarantee in Article 1, Section 19 should direct the court to understanding that a motivating factor means that it was part of what motivated. The court can also draw an inference of intent from the totality of relevant circumstantial facts. That inference is important. It's important that this court not miss the forest for the trees. And in this case, we believe you will be invited to view and dismiss each of the individual facts on their own. That was the same error that the district court in the House Bill 589 case made, and it's why the Fourth Circuit reversed the district court there. So in Arlington Heights, the Supreme Court listed a non-exhaustive number of factors that could be considered in the sensitive inquiry into legislative intent. And in the demonstrative on your screen, you will see the different buckets of evidence, if you will. Non-exhaustive, meaning that there is more. There can be more. that the Supreme Court has instructed us to look at. First, the historical background of the challenge decision. Second, the sequence of events leading up to the challenge decision. Third, the legislative history of the decision. Fourth, the impact of the official action, whether it bears more heavily on one race than another. And then additional evidence that we contend would be probative. I'm going to address each of these buckets in turn, and I'll try and keep coming back to this slide to help the court orient where we believe the witness testimony is relevant. I'd like to, Your Honor, if I can pause for a second. We just got invited to join a breakout group. I'm assuming that's not what we need to be doing right now.
Yes, sorry, I created them. I apologize. It's Kelly Myers.
Oh, thank you, Ms. Myers. No worries.
Yes, sorry.
All right, so I want to start with the historical background of the legislation at challenge here. The enactment of Senate Bill 824 did not happen in a vacuum. We will be putting on evidence from several experts to discuss the historical background. The first will be Dr. Carol Anderson, a professor of African American Studies at Emory University. Professor Anderson's research and teaching focus on public policy, particularly the ways that domestic and international policies intersect through the issues of race, justice, and equality in the United States. And it's relevant to what's happening in North Carolina because it provides context for voter ID laws about how they're not about or explained by partisan policy preference. Across the country, she will explain the effect that they have and how they create barriers for Black voters, the same voters who already face barriers caused by the history of discrimination in our country. I'll talk more about this topic when I talk about why this law is about racial discrimination and not just some quote unquote acceptable level of partisan politics. We'll also be calling Dr. James Laludis, a professor of history at the University of North Carolina at Chapel Hill, who has for more than 30 years taught and researched the history of North Carolina politics, government, and public policy. Dr. Laludis served as an expert witness for the plaintiffs who successfully challenged House Bill 589 in the McCrory case in 2016. Dr. Laludis will document and explain the history of voting and election laws in North Carolina, and that is characterized by recurring cycles of expansion of the franchise to African Americans, followed by a backlash and retrenchment in which the General Assembly enacts new, facially neutral measures, often justifying them as necessary to address purported voter fraud that targets methods of participating in elections used by African Americans with the intent and effect of restricting their ability to vote. Dr. Laludis will explain that Senate Bill 824 fits squarely in this observed historical pattern, as it is the latest example of a backlash and retrenchment against expanded access to the ballot for African Americans in North Carolina. The other part of the historical background of this case is House Bill 589, enacted in 2013 and struck down by the Fourth Circuit Court of Appeals in 2016 because the provisions of the law targeted African American voters with almost surgical precision. House Bill 589 is relevant for many different reasons, but it's important to note how it started. House Bill 589 was enacted in the wake of a United States Supreme Court invalidating the coverage formula and thus removing the protections of Section 5 of the Voting Rights Act. Within days of that decision that the legislative leadership celebrated, the legislature acted to impose restrictions on voting that would have never passed muster under Section 5. This is not ancient history. This is in this decade. These are cases that we have collectively, those in the courtroom, worked on and lived, and our electorate has been affected by that law. Now, Again, the legislative defendants may tell you this isn't relevant, but the North Carolina Court of Appeals said it is, as a matter of law, is part of the broader context, and that interpretation of Article 1, Section 19 is binding. Of course, House Bill 589 alone is not dispositive. We aren't saying it is, but it is a relevant piece of the broader context the Court of Appeals instructed this court to take into consideration. We've gone over the historical background. Now I want to talk about the disparate impact of the official action. Your Honors, voters will be harmed by this law, and they are disproportionately Black. Our plaintiffs in this case, that you see on the screen, are voters of color who are standing up against a racially discriminatory voter ID law. They are voters that face barriers to voting already, and they are voters who are targeted by previous laws and this law in an attempt to keep Black North Carolinians from voting. But we don't just have stories. We have quantitative data on the disparate impact of this law. You'll hear from Dr. Kevin Quinn, a professor of political science and statistics at the University of Michigan, and an unparalleled leader in the field of political methodology. Dr. Quinn performed an analysis where he matched the voter registration file to files of people holding qualifying IDs under Senate Bill 824, where those lists were available. And here's what you'll hear that he found. Black voters are 39% more likely to lack qualifying photo ID than white registered voters. I recommend to the court that it not be distracted by arguments or invitations to parse exactly how discriminatory the effect is. It is a significant disparity, and that means there's a significant racial effect. Moreover, this is not simply about Black voters in North Carolina being less likely to vote. Dr. Quinn looked at likely voters, and the racial disparity was even worse. Looking at recent voters who actually voted in the 2018 and 2016 elections, so voters deemed to be likely voters, Dr. Quinn found that Black voters are twice as likely to lack qualifying ID, twice as likely. These figures on your screen are real voters, not just numbers and graphics. This afternoon, you'll hear from Elizabeth Holmes, the mother of our lead plaintiff, Jabari Holmes. This law creates expected and predictable barriers for Black voters and for their families. And throughout the trial, you'll hear from other plaintiffs as well. You'll also hear from Noah Reed, a member of the Alamance County Board of Elections, about the challenges facing rural voters where, as in many counties in this state, access to public transportation is lacking. And you'll hear about how it can affect communities of color in those rural areas. You'll hear from Kate Fellman, the executive director of a nonprofit called You Can Vote, that provides direct services to tens of thousands of voters trying to understand and navigate the rules of political participation. You'll hear from her and based on the conversation she's had, that voters lack ID, that voters are deterred when more barriers are created, and that voters are intimidated by the reasonable impediment process. Plaintiffs will argue that this law will not and cannot be implemented in a non-discriminatory way, and that the North Carolina General Assembly knew or reasonably should have known that. In support of our claims that both House Bill 589 was and Senate Bill 824 will be problematically implemented, we will call Dr. Ariel White, a professor of political science at MIT. Her research focuses on political behavior in the United States, including voter turnout and the behavior of election workers and other public-facing government employees. Her research indicates that human discretion can lead to biased decision-making, and that this is especially evident with regard to elections, where poll workers have extreme discretion and are often required to make snap judgments. Dr. White determined that voter identification laws, including Senate Bill 824, which requires the addition of extra discretion points, can lead to biased decision-making as well as increased error. Such biased decision-making and potential for error disproportionately affects African American voters who, because they lack identification in higher numbers, are forced to interact with and thus rely more on poll workers. You'll hear some of that research and how it manifests in real life here in North Carolina from Paul Kearney, one of our plaintiffs, a voter affected by House Bill 589's poor design replicated in Senate Bill 824. Mr. Kearney forgot his ID. Poll workers did not tell him how to cure his provisional, let alone that it would not count if not cured, and he was disenfranchised. You'll hear from Daniel Smith, who, like many of us, had to get a replacement driver's license when he lost his. He had the temporary ID with him, but it was not accepted. He was not offered a reasonable impediment ballot and not told how to cure his provisional ballot. Disparate impact includes evidence of implementation, not because it's an as-applied case or because it's turning it into an as-applied case, but because the legislature had evidence in front of it during the legislative process that there were problems with implementation. Ashley, you can take this slide down for a minute. Plaintiffs believe it's important for this court to not only grapple with what was in front of the legislature, but given that information, why the legislature didn't ask certain questions. It's not that the General Assembly has to ask certain questions in any and every legislative act, but their failure here, in light of recent history and evidence of implementation issues, should raise red flags. In the totality of relevant facts, it is consistent with an inference that improper motives were at play. And again, House Bill 589 becomes relevant. Lessons were not learned because these questions weren't asked. If you had just been found guilty of racial discrimination in imposing a voter ID law, why wouldn't you take more care to carefully craft a law rather than to rush it? It's still our burden, of course, in this case, but that doesn't mean that the court shouldn't ask why the legislature didn't look to see if the allegedly ameliorative changes really made a difference. At bottom, here's what the court needs to understand on disparate impact. That Black voters may be able to jump through additional hurdles to be able to get an ID or to have a provisional ballot that's counted doesn't negate the disparate impact. That white voters may also be able to jump through additional hurdles to be able to get an ID or have their provisional ballot counted doesn't negate the disparate racial impact. So that evidence that I described will go into the disparate impact bucket. I now want to talk about the sequence of events. If you'll notice in the buckets along the bottom of the screen, I'm going to discuss sequence of events and then legislative history. Sometimes these buckets can get merged, but I want to address them separately and just note that some of the evidence and witnesses will testify to topics that go into both buckets, the sequence of events and the legislative history. So I want to talk about now the timeline in 2018, the sequence of events. On June 28th, 2018, the United States Supreme Court ruled definitively and finally in the case Covington versus North Carolina, requiring remedy districts be put into place for the 2018 elections. I won't go into the details of that case, but it was obvious to everyone, and you'll hear testimony confirming this, that everyone knew that the Republicans would lose their supermajority because those racially gerrymandered districts had to be fixed. That happened on June 28th. On the next day, June 29th, the legislature enacted House Bill 1092, which put a constitutional amendment on the ballot for November, asking voters to approve a vague requirement for a photo ID. And the same day, they weirdly adjourned to the session to reconvene later after the election. Going down the timeline, on November 6th, the ID amendment narrowly passed. The obvious was confirmed. And the obvious was confirmed. The Republicans in the legislature lost their supermajorities in both chambers. What that meant is they didn't have the vote to override a veto. And so they moved into a lame duck session to ram through a law that would have certainly and did draw a gubernatorial veto, and that after the duly elected legislature was seated in January, would not have been able to be overridden. Your Honors, here you have two very obvious, very different, very questionable sequences of events. What happened in June and what happened in November, December. The timing of all of this should be raising red flags galore, and we don't have to leave common sense at the doorstep of the courthouse when looking at this. Now I'm going to talk about legislative history and what some of our witnesses will offer you on this topic. And really the point of this inquiry is understanding how did the North Carolina General Assembly get to the point of enacting Senate Bill 824 from a legislative standpoint. First, Your Honor, understanding the legislative composition of who voted in 2018 is important. This demonstrative shows the votes in 2018, but we want to highlight for the court that 62 of the legislators who voted for Senate Bill 824 also voted for House Bill 589. Of course, there are 50 members of the Senate, 120 members of the House. Our legislators are not paid enough. It's not a full-time job. So there's a lot of churn. The same 170 members present in 2013 were not the same 170 members present in 2018. But even with that churn, there is an enormous chunk of people voting in support of both bills, one confirmed to be racially discriminatory. This evidence, like many of the other pieces we'll present, is not dispositive in and of itself, but it is relevant. Now I want to talk about who you'll hear from about legislative history and the sequence of events. The witnesses whose pictures are depicted here will address and present testimony that falls into both buckets. Sabra Ferris is an expert who spent over 20 years in the North Carolina General Assembly, advising legislators on proper process, and has seen the very North Carolina legislative processes in question longer than anyone else involved in this case, to my awareness. She noted an incredible number of irregularities that made this process aberrational, represented a departure from normal practices, and should give rise to an inference of impropriety. Just to name a couple of things, there was no enabling legislation put forward with the constitutional ballot measure. So the voters didn't know what they were voting on. The legislators wrote themselves a blank check, and that was not the most common practice for constitutional amendments that required enabling legislation. It was also a strange lame duck session. It was a lame duck session that those are infrequent enough, but this was one where the controlling majority had just lost its supermajority. Voters had voted them out, had said, we don't want these representatives to hold unchecked power. And this is the legislature that rammed through this bill. Representative Pricey Harrison and Senator Gladys Robinson, longtime members of the North Carolina General Assembly, will also testify to the rushed, irregular process that, contrary to what you may hear from my colleagues across the aisle, this was not, in fact, a bipartisan process, and can contrast it with actual bipartisan processes, and that legislators asked for updated data about the racial impact and didn't get it. I mentioned earlier that this also goes to the legislative history. I mentioned that the legislature had in front of it data about problems with implementation. Ashley, if you can go to the next slide. Data, we'll pull that up now, but data provided by then Executive Director of the State Board of Elections, Kim Strack, to a joint committee on November 26th, right before the legislature reconvened, was that data of problems. In Ms. Strack's presentation, she explained to the Legislative Joint Committee that in a primary, the March 2016 primary, 1,048 voters had to use a reasonable impediment declaration. These are voters that the state board did not get a photo ID to. These are voters who were pulled out of line. These were voters who were shamed and othered. And Ms. Strack didn't hide the fact that all of those reasonable impediment declaration ballots weren't counted. If you'll do a little math with me, 1,048 minus the 864 that were counted means that 184 reasonable impediment ballots didn't count. Now, you might hear that some of these numbers changed over time with more inquiry. That doesn't matter at all. This case is about what the legislature knew when it enacted Senate Bill 824, and this is what we knew. Additionally, then Director Strack noted that in the March 2016 primary, 1,248 voters did not present a photo ID, did not execute a reasonable impediment declaration, or did not return to cure their absentee. Again, whether or not these numbers changed a little bit later on more inquiry, this is what the North Carolina General Assembly knew when it enacted Senate Bill 824, that in a primary election, the safety nets didn't work for over 1,200 voters. It is an important part of the legislative history that the North Carolina General Assembly knew that voters were disenfranchised under a substantially similar law. And make no mistake, Senate Bill 824 is substantially similar to House Bill 589. The last bucket of additional elements is less well-defined in case law. But one thing we wanted to raise for this court's focus is that North Carolina has a long history of racially polarized voting. And you'll hear from witnesses that no one really disputes that Black voters overwhelmingly support Democratic candidates. Black cohesive voting is a part of racially polarized voting. Now, the Fourth Circuit has said racially polarized voting is not in and of itself proof of racial discrimination, but it does provide an incentive for intentional discrimination in the regulation of elections. The U.S. Supreme Court, in a 2006 redistricting case out of Texas, noted that in a district where there was rising Latinx political power and Latinx voters had almost unseated an incumbent, that when the Texas legislature redrew the district lines, the threat to the incumbent motivated the controlling party to dilute the minority vote. These are strategies that are relevant to the circumstantial evidence and help us meet our burden in proving that race is a motivating factor. And once we have done that, the burden shifts to the state to demonstrate that the law would have been enacted without this factor. This is important, Your Honors, because at this point, the court must scrutinize the legislature's actual motivations, and it is not rational basis review. It is not what could have motivated them, it is what actually motivated them. So I want to look at what some of the neutral state interests that you're likely to hear or may hear that might that you may hear might have justified the law besides racial discrimination. First, that the adoption of the constitutional amendment justifies racially discriminatory enabling legislation. At issue in this case is not whether a law was needed, but whether this particular law was needed. The legislature cannot inoculate itself against the disease of a racially discriminatory law by simply proposing a constitutional amendment before passing that law. If this were true, the legislature could get almost anything passed with impunity by amending the Constitution with a vague ballot measure, as they did here. That this was put to voters and a bare majority approved, the ID amendment does not give the legislature a free pass to pick winners and losers through a discriminatory law. You may also hear that the adoption of the constitutional amendment required the legislature to pass enabling legislation in a lame duck session. That's categorically not true. Voters also approved a constitutional amendment called Marcy's Law. It's a victims' rights constitutional amendment. That constitutional amendment also needed enabling legislation, but that enabling legislation was not passed until the 2019 long session by the legislature duly enacted by the voters in November of 2018. The same electorate that barely approved the amendment also said they did not want a supermajority of Republicans making this policy in this state. They voted on a law with exceptions, but there's no evidence that this particular law, Senate Bill 824, would have been approved by voters. Then you may hear that this voter ID law is justified by purported concerns for voter fraud law as written. That's not true. You'll hear from legislative defendants' own witnesses that there's no history of widespread voter impersonation that needs to be remedied. And even if there were, the reasonable impediment process here might not even prevent that. There's simply no basis in evidence for the state to carry its burden on defending these alleged neutral state interests. And finally, there's no basis to suggest that discrimination could ever be a competing interest that the North Carolina General Assembly had to factor in. The North Carolina Court of Appeals and many other courts have said racial discrimination is not just another competing consideration. And it's important because the Court of Appeals in North Carolina noted that judicial deference to the legislature is no longer justified at this point in this kind of case. The state's proffered non-racial interests must be sufficiently strong to cancel out any discriminatory motive. Thus, walking through the Arlington Heights analysis, plaintiffs will have met their burden, and after the burden shifts, defendants will have failed to carry theirs. Lastly, as I wrap up, Your Honors, I want to dispel a few misconceptions that you're likely to hear throughout the trial and in it as witnesses testify. This case is not Abbott v. Perez. My organization litigated Abbott v. Perez for almost a decade, and we argued it in the Supreme Court, and we can explain how this case bears almost no resemblance to that case. There, a trial court had to draw an interim redistricting plan because Texas did not get preclearance for its maps under Section 5. After that interim plan was put in place, the Texas legislature adopted the interim plan, even though plaintiffs alleged there were still issues that hadn't been corrected in the interim plan. The Supreme Court said the trial court improperly shifted the burden to Texas from the beginning. The state had relied on a federal court drawn plan, which obviously couldn't have been drawn with discriminatory intent, and that the adoption of the interim plan was an independent intervening event. But this is exactly why Abbott is inapplicable here. There was no federal court drawing up this law. The voters can't be blamed for the intervening event because they never saw the details of this law. And we are not inviting this court to prematurely do any burden shifting. Second, you may hear that the Fourth Circuit's decision on the federal preliminary injunction from December 2020 should control here. We believe it is not dispositive or all that informative. While we respectfully disagree with the Fourth Circuit that the district court considered the legislature's 2013 discriminatory intent as effectively dispositive and flipped the burden at the first step, we are not doing that here. We are not asking the state to bear the risk of non-persuasion with respect to intent. The Fourth Circuit said the district court penalized the General Assembly because of who they were instead of what they did. I promise you'll hear quite a different story in the next couple of weeks, such as how unprecedented the lame duck's regular session was in which Senate Bill 824 was passed, how the constitutional amendment did not include implementing legislation or even tell voters that implementing legislation would need to be enacted. We believe this is new evidence for this court to consider in the full merits, not on a preliminary injunctions record. Lastly, the constitutional amendment vote is not an independent intervening event between 2013 and 2018. Maybe if there had been enabling legislation with the constitutional amendment, this would have been a closer call. But what we know is voters barely approved an ID law with exception and without other relevant details. And so it cannot be seen as a voter's endorsement of Senate Bill 824 or an intervening event. Your Honors, this case is not about racial animus. You will not hear any attorney or witness in this case call legislators names. Nor is this about the court trying to discern the level of racial bias in the heart of any legislator. The intersection of race and politics in this state can create an incentive for the party that was in the majority passing the bill to make it harder for Black voters to vote. The Fourth Circuit in McCrory said, using race as a proxy for party may be an effective way to win an election. But intentionally targeting a particular race's access to the franchise because its members vote for a particular party in a predictable manner constitutes discriminatory purpose. This is so even absent of any race-based hatred and despite the obvious political dynamics. A state legislature acting on such motivation engages in intentional racial discrimination in violation of the 14th Amendment. The Republican supermajority that had just been ousted acted on that same motivation in December of 2018. Lastly, I've addressed this before, so I'll be brief. Implementation evidence is relevant because those questions were squarely teed up in front of the legislature when it was making its decision. That consideration of implementation evidence does not turn this into an as-applied case. Lastly, you may hear that later amendments to the voter ID statutory scheme change the question, the legal question. That's wrong. The question before the court is, why was Senate Bill 824 enacted? In 2019, sure, there were changes to how student IDs would be approved. But the fact that they had to make those changes in 2019 is only evidence of how rushed and ill thought out the initial process was in 2018. And again, why did the legislature do what it did in December of 2018 with Senate Bill 824? The addition of public assistance IDs in 2020 might be brought up. The addition of public assistance IDs doesn't enable a single, as written, does not enable a single additional voter to vote. So it's even more outrageous and suspect when no such qualifying IDs exist. Any changes to the statutory scheme do not change the question before this court or the proper remedy. Briefly, this is directly analogous to what happened in the House Bill 589 litigation. On the eve of trial in 2015, the legislature enacted a modification to the statutory scheme to create the reasonable impediment process. The Fourth Circuit in McCrory said, even if the state were able to demonstrate that additional process lessened the discriminatory effect of a photo ID requirement, it would not relieve us of our obligation to complete a remedy and invalidate the law. The burden rests on the state in any effect to prove that any proposed remedy completely cures the harm. Your Honors, at the close of evidence, plaintiffs believe that you'll agree with us that the mountain of circumstantial evidence is so overwhelming that no alleged neutral justifications can overcome that mountain. Plaintiffs don't need smoking gun evidence. That almost never exists anymore. But as instructed by the North Carolina Court of Appeals and federal courts, we will have built an undoubtable case on the vast array of circumstantial evidence. And at the end, you'll conclude that North Carolina once again enacted an unconstitutional law, a voter ID law designed to keep Black voters from the ballot box. And you'll enjoin that law as necessary when a law is enacted with such improper motivations. Thank you for your time, Your Honors.
Thank you, Ms. Riggs. This looks like a pretty good time to go ahead and take our morning break. So we're going to take about a 15-minute break. We'll come back at 11:15. All right, thank you.